Nu är det dags för Danmark. Jag bjuder Astrid Maurogenes välkommen. Hon är kontorchef i Civilstyrelsens fri processkontor och hon behandlar saker om fri process och rättshjälp. Hon har bland annat publicerat bok i 2012 om fri process och rättshjälp. Varsågod.
Jeg vil først gerne sige tak for invitationen. Det er meget spændende at høre, og med fare for, at jeg ikke har forstået de forskellige indlæg, så tror jeg, at jeg kan fornemme, at der er nogle ret betydelige forskelle på de danske ordninger, i hvert fald den del, som hedder fri proces, og noget af det, vi har hørt om tidligere. Jeg har ikke sådan en fin forside, men jeg kommer fra Civilstyrelsen, som er en myndighed under Justitsministeriet. Vi behandler sager om fri proces og retshjælp, og vi laver også de administrative regler. Men vi laver ikke selve lovgivningen, fordi selve loven, reglerne findes i den danske retsplejelov, og den hører under selve Justitsministeriet. Men vi laver noget, der hedder en bekendtgørelse om fri proces, og vi har lavet en bekendtgørelse om offentlig retshjælp ved advokater, og vi har også lavet nogle regler, som handler om rådgivning i private retshjælpsinstitutioner. Civilstyrelsen behandler sager om fri proces i første instans, og de afslag, vi giver, de kan påklages til et nævn, som hedder Procesbevillingsnævnet, hvor formanden er en landsdommer, så er der et medlem, der er dommer i byretten, og så er der en advokat. Jeg vil lige sige, at mine slides, det er sådan en skøn blanding af dansk og engelsk, og jeg ved ikke, om det hjælper jer, men måske, det håber jeg. Men legal aid eller retshjælp, det kan i Danmark være flere forskellige ting. Det kan være fri proces, så kan det være rådgivning hos en advokat, det kan være rådgivning i en privat retshjælpsinstitution, og så kan det også være hjælp til betaling af omkostninger i sager ved internationale klageorganer vedrørende menneskerettigheder. Og de 3 første punkter, de er reguleret i retsplejeloven. Det sidste med de internationale klageorganer, det har sin egen lov. Men vi behandler også sager vedrørende retshjælp til klageorganerne. Det jeg først og fremmest vil fortælle om, det er reglerne om fri proces. Og det vil jeg gøre, fordi efter min mening, så er det et meget vigtigt bidrag for borgernes adgang til domstolene eller access to justice. I modsætning til, hvad vi har hørt fra nogle af de andre lande, så er det sådan, at omkostningerne til fri proces, de følger finansloven på noget, der hedder en lovbunden konto. Og det betyder, at der ikke er noget budget, der er ikke noget maksimum. Så der skal være den udbetaling, som der reelt er af omkostninger i de enkelte sager. Og i 2013 var der udgifter i, og det er kun civile sager, på 475 millioner danske kroner. Og ligesom i de andre lande, vi har hørt, så har vi også den ordning, at fri proces er subsidiær i forhold til retshjælpsforsikringerne. Jeg ved ikke, hvor stort beløb, der er udbetalt for retshjælpsforsikringerne, men det er formentlig også betydelige beløb. Inden jeg går videre med, hvad retsvirkningerne af fri proces er, så vil jeg godt sige, hvad man har tænkt, at formålet skulle være. Jeg skal lige høre, kan I forstå, hvad jeg siger? Går det for hurtigt, eller er det okay? Okay, ellers må I sige til. Formålet med reglerne om fri proces, det er at give borgere med mindre gode økonomiske muligheder lige adgang til domstolene som borgere med bedre økonomiske muligheder. Men det betyder ikke, at de skal have bedre adgang til domstolene, fordi de har en lav indkomst. Og en af de bærende elementer i reglerne i Danmark, det er, at jeg tror, at vi har en anden sorteringsmekanisme i, hvordan vi skiller de sager, der får fri proces, og de sager, der ikke får det. Fri proces i Danmark, det dækker civile retssager. Straffesager, det kører for sig. Det har vi ikke noget at gøre med i Civilstyrelsen, og det ved jeg ikke noget om. Men der er faktisk ret vide retsvirkninger af en bevilling om fri proces. Og det vil jeg lige starte med at fortælle, inden jeg går over til at fortælle om, hvad betingelserne er. Hvis man bliver meddelt fri proces, og det gælder både en borger og det kan være en fysisk person, men det kan også være juridiske personer. I udgangspunktet er der ikke nogen begrænsninger på, hvem der kan få fri proces. Foreninger, virksomheder, sammenslutninger, heller ikke kun ideelle sammenslutninger, kan få fri proces, hvis betingelserne er opfyldt. Betingelserne vender vi tilbage til. Hvis man får fri proces, så får man beskikket en advokat af retten, og når sagen bliver sluttet i retten, så fastsætter retten, hvor stort et salær, der skal betales. Der er ikke noget med timeantal, men det bliver lavet på baggrund af en opgørelse fra advokaten om, hvor mange timer der er brugt, og det indgår så i en samlet vurdering af, hvor stort et salær, der skal gives. Fri proces medfører også fritagelse for betaling af retsafgifter. Så dækker det fritagelse for udgifter til bevisførelse, f.eks. assistance fra eksperter. Det kan også dække tolkning eller oversættelse. Og så dækker det grundlæggende tvangsfuldbyrdelse i det omfang, man får medhold selvfølgelig. Og en sidste ting, som nok er ret vigtig, det medfører også, at man fritages for at betale omkostninger til modparten, hvis sagen tabes. Hvis sagen tabes, så er det så staten, der betaler de omkostninger, modparten skal have, og det vil så typisk være et advokatsalær. Der kan også være andre omkostninger, men det er retten, der fastsætter, hvor meget det skal være. Omvendt er det så, hvis den, der har fri proces, vinder sagen, så skal statskassen have omkostninger fra modparten. Så jeg tænker, at de retsvirkninger, der er af fri proces, fordi de ikke er maksimeret på andre måder, end det retten fastsætter ved sagens afslutning, så er de ganske vidtrækkende, også i forhold til nogle af de andre ordninger, vi har hørt. Men det er klart, at der skal jo være en eller anden form for sortering. Der skal jo være nogle betingelser. Og det er måske et af de punkter, hvor den danske ordning adskiller sig fra de andre ordninger, vi har set. Forstået på den måde, at vi har nogle økonomiske betingelser. Jeg vil se, om jeg kan finde den. Jeg har prøvet at putte dem ind i sådan en meget grov gruppe. Paragraf 325, den handler kun om fysiske personer. Den angår de økonomiske betingelser og betingelsen om, at man ikke må have en retshjælpsforsikring, der dækker sagen. Så har vi i 328 en betingelse om, at der skal være rimelig grund. Og det betyder faktisk i de fleste tilfælde, at ansøgeren skal kunne vinde sagen. Og det er der, jeg tror, at der kommer noget ind, som bliver lidt anderledes end i nogle af de andre ordninger. Så den der udsigt til medhold, det bliver en eller anden form for domstolslignende prøvelse. Så har vi i den sidste en undtagelsesbestemmelse, som indeholder en masse undtagelser. Den indeholder undtagelser til den allerøverste om de økonomiske betingelser, og den indeholder også en undtagelse om retshjælpsforsikring, men der er ikke nogen undtagelse om rimelig grund. Man skal altid have rimelig grund til at føre proces. Det den sidste også handler om, det er de sager, som bliver givet, fordi der er særlige grunde Det kan være sager, der er principielle eller almindelig offentlig interesse, eller sager, som har særlig stor betydning for ansøgerens sociale eller erhvervsmæssige situation. Men det er en snæver undtagelsesbestemmelse, og den bruges på de særlige grunde ikke meget. Det er sådan, at... der var den engelske. Den venter vi lige med. Tager lige den engelske. Det er sådan, at i Danmark, der er kompetencen til at meddele fri proces. Den er delt mellem Civilstyrelsen, det er der, hvor jeg er, og domstolene. Og grunden til, at man har lavet den opdeling, det er, at man har i loven udskilt en særlig gruppe sager, hvor betingelsen deroppe i 325 skal være opfyldt. Men hvor der derudover er en formodning for, at man har rimelig grund til at føre proces. Og det er mange sager om forældremyndighed, det er sager om separation og skilsmisse, det er bodelingssager, og så kan det være sager, hvor der tidligere er lavet en prøvelse af udsigten til medhold, hvis en forbruger har fået medhold i et klagenævn, men den erhvervsdrivende ikke vil efterkomme den afgørelse, klagenævnet har truffet, så har man en nemmere adgang til at få fri proces, hvis man er nødt til at føre en retssag for at gennemføre sit krav. Men der skal stadigvæk være en eller anden form for rimelig grund til at føre proces, forstået på den måde, at det må ikke være åbenbart, at man ikke kan vinde sagen. Og i forbindelse med forældremyndighedssagerne, det var det, du var ude og tale om, hvorvidt reglerne kan være procesdrivende, så har man forsøgt at indsætte en barriere for, hvornår sager om forældremyndighed kan blive indbragt for retten. Og det er nemlig sådan, at i Danmark kan man ikke selv indbringe en sag. Det skal ske via en offentlig myndighed, som tager stilling til, om sagen kan indbringes. Så hvis den offentlige myndighed ikke vil indbringe sagen, så kan man ikke føre sin forældremyndighed. Så kan man så føre en sag mod den offentlige myndighed om, at man ikke måtte føre sagen. Men det er så noget andet. Ja. Jeg vil gå videre og se på det, der står i den øverste om de økonomiske betingelser og retshjælpsforsikringen. Og jeg starter med retshjælpsforsikringen, fordi det er den nemmeste. Jeg ved ikke, hvor mange mennesker i Danmark, der har en retshjælpsforsikring, men det er jo nok ret mange. Men det er jo nok ikke ret mange af dem, som har en lav indkomst, der har en retshjælpsforsikring. Så vidt jeg ved, så har retshjælpsforsikringer i Danmark nu et maksimum, der ligger omkring 175 til 200.000 danske kroner per forsikringsbegivenhed. Og det vil så sige, det er jo en retssag, men det kan også være i flere instanser. Så den kan jo godt blive opbrugt. Og hvis man opbruger sin retshjælpsforsikring, så kan man så søge om fri proces på lige vilkår som dem, der ikke har. De økonomiske betingelser har vi også i den bestemmelse, der ligger deroppe. Og der var den engelske igen. Og de økonomiske betingelser, de er fælles for både de sager, der behandles ved domstolene, og de sager, som behandles i Civilstyrelsen. Indtægtsgrænserne i 2014, de er for enlige 299.000, samlevende 380.000, og så er der et tillæg for hvert barn under 18 år, der bor hjemme. Og det kan være egne børn, det kan også være stedbørn, hvis man har en sammenbragt familie. Og der er ikke nogen grænse for, hvor mange. Altså hvis man har 7 børn, så skal man også have 7 gange 52.000 i børnetillæg. Så det vil sige, at indtægtsgrænsen kan flytte sig ret højt op. Jeg ved ikke, hvor stor en del af den danske befolkning, som opfylder de økonomiske betingelser. Så vidt jeg ved, så har det ikke været sådan rigtig analyseret siden 1996. Og i 1996 fandt man ud af, at 49% af befolkningen, og det gælder både enlige og samlevende, opfyldte de økonomiske betingelser. Jeg gætter på, at det er nogenlunde det samme i dag. For det er sådan, at indtægtsgrænserne de bliver reguleret hvert år. Hvert år med virkning fra 1. januar, så har vi i Civilstyrelsen lavet en ny bekendtgørelse, hvor vi har udregnet de indtægtsgrænser, der skal gælde for det næste år. Der var den på engelsk. Ja, altså, den ser lidt voldsom ud, men jeg sætter nogle ord på, og så kommer vi forhåbentlig igennem den. De sager, jeg primært kommer til at tale om, det er de sager, som behandles i Civilstyrelsen, det vil sige i den centrale administrative myndighed. Og det, vi skal tale om nu, det er spørgsmålet om rimelig grund. Som jeg sagde før, så har domstolene kompetencen i en række sager, hvor der ikke skal laves en vurdering af, om man har udsigt til at vinde sagen. Og man har opregnet specifikt, hvad det er for nogle sager i loven. Og grunden til, at man ikke ville have, at domstolene skulle tage stilling til, om ansøgeren kunne vinde sagen, det var, at det ville være uheldigt, hvis den samme dommer skulle sidde og tage stilling til spørgsmålet om fri proces, herunder om man kan vinde sagen, og så efterfølgende afgøre selve retssagen. Så på den måde er tingene skilt ad. Så denne her vurdering af, om man kan vinde sagen, den ligger så hos os i første instans. Bestemmelsen i 328, den gælder kun fysiske personer. Man har i loven indsat en række kriterier, som man bruger til at vurdere, om der er rimelig grund. Fordi rimelig grund, det er sådan set bredere end udsigt til medhold. I rimelig grund indgår blandt andet sagsgenstandens størrelse. Det betyder, at hvis man vil føre sag om en meget lille sagsgenstand, så kan man ikke få fri proces, hvis man er sagsøger. Men er man sagsøgt, så kan man godt, fordi så har man jo ikke selv styret processen, så er man blevet sagsøgt. For en sagsøger, så ligger grænsen nok omkring en sagsgenstand på 3.500 danske kroner. Så har man også en bestemmelse, som handler om de forventede omkostninger ved retssagen. Det er sådan en eller anden cost-benefit-tanke, men det er faktisk ikke en bestemmelse, der bruges i praksis. Jeg har aldrig været med til at bruge den, og jeg tror faktisk ikke, den bliver brugt. Men man har jo så tænkt den ind, da man lavede reglerne. Muligheden for behandling ved et administrativt klagenævn kan indgå. Man skal ikke føre proces, hvis man kan få sagen behandlet i et godkendt klagenævn. Hvis man kan få sagen behandlet hos en administrativ myndighed, så skal man heller ikke føre proces, før man har fået afgørelsen. Så kan man så føre proces, når man har fået afgørelsen. Så skal man anlægge en sag mod myndigheden. Det vil være systemet. Og så er der også sagens betydning for ansøgeren. Og det er jo klart, det er sådan et meget elastisk begreb, men det er selvfølgelig ud fra en objektiv vurdering, hvor vigtigt er det at føre denne her sag for ansøgeren. Den sidste ting, sagens vigtighed for ansøgeren, sammenholdt med, kan ansøgeren vinde sagen, det er de bærende elementer i spørgsmålet om, man bevilger fri proces, når de økonomiske betingelser er opfyldt, og der ikke er en retshjælpsforsikring. Det er der, man kan sige, det hele står og falder. Og det er klart, at der er mange advokater, som synes, at det er meget irriterende, at der skal være en offentlig myndighed, som sidder og tager stilling til, om der er rimelig grund til at føre proces. Men sådan har man lavet systemet, og det er forudsat, at vi tager stilling. Og det gør vi selvfølgelig også ved at lave en skriftlig afgørelse, og hvis vi giver et afslag, så skal det jo begrundes. Det skal selvfølgelig ikke begrundes som en dom, for vi afsiger ikke domme. Men det vi gør, det er, at vi går ind og skitserer sagens hovedtema, som jo typisk vil være et bevistema. Spørgsmålet om, hvem skal bevise hvad i denne her sag. Og det er spørgsmålet om, hvorvidt ansøgeren eller modparten, hvis det er modparten, der har bevisbyrden, kan løfte denne her bevisbyrde. Det er selvfølgelig ikke sådan, at det kun er sager, hvor vi er helt sikre på, at man vinder sagen, der bliver givet fri proces. Der er altid en margen, og det skal der også være, og det skal også komme borgeren til gode i et eller andet omfang. Men den grundlæggende tanke er stadigvæk, at der ikke skal føres sager, som man ikke selv ville have ført. Altså, det er ligesom, man skal ikke føre sager på statskassens regning, som man ikke selv ville føre, hvis man skulle betale selv. Det er en grundlæggende ting. Så er der selvfølgelig alligevel nogle undtagelser, fordi vi har nogle sagstyper, hvor der er en lidt mere lempelig vurdering af prøvelsen om udsigt til medhold. Og det gælder i sager om ophævelse og opsigelse af lejemål, ophævelse og opsigelse af ansættelsesforhold og skadelidte i personskadesager. I de sager, der er der en formodning for, at ansøgeren har rimelig grund til at føre proces. Det er ikke det samme, som vi så i de sager, der lå hos domstolene, hvor det er mere sagens betydning, og der ikke må være forhold, der åbenbart taler imod. Her er det lidt anderledes. Der skal stadigvæk være udsigt til medhold. Der må bare ikke være noget, der taler klart imod den. Jeg startede med at sige, at alle kan få fri proces, og det gælder både fysiske og juridiske personer. Og jeg tror også, jeg sagde, at det gælder i alle sager, alle civile sager, alle sager, som kan føres ved de danske domstole, der kan man i udgangspunktet få fri proces. Reglerne er lavet meget fleksibelt, fordi de skal forme sig efter den underliggende retssag. Men man har i loven valgt at tage 2 typer af sager ud. Og det drejer sig om sager af erhvervsmæssig karakter, hvor man er tilbageholdende ved at meddele fri proces. Det er ikke sådan, at det ikke kan finde sted. Det kan det godt. Der skal bare være nogle særlige grunde til, at man skal give fri proces. Og det kan typisk være, hvis det er en lille erhvervsdrivende, som er blevet mødt med et stort krav, og der er tale om et usædvanligt led i driften af virksomheden. Og ansøgeren skal have behov for bistand i form af fri proces. Hvis de betingelser er opfyldt, så kan man lade være med at kigge på, at sagen er erhvervsmæssig, men man skal stadigvæk opfylde de andre betingelser. Man skal stadigvæk også kunne vinde sagen. Ellers får man ikke fri proces. I forbindelse med finanskrisen i Danmark, som jo har stået på i nogle år, jeg ved ikke, om den er afblæst, men der har vi oplevet en betydelig stigning i antallet af ansøgninger om fri proces fra erhvervsdrivende. Og det er der måske ikke noget så mærkeligt i, men grundlæggende så ændrer det ikke på, om man kan få fri proces eller ikke. Vi har selvfølgelig bare fået en større volumen af sager at sidde og tage stilling til, men det er stadigvæk de samme betingelser. Altså konjunkturforskydninger spiller ikke ind i forholdet til spørgsmålet om fri proces. Når vi taler om juridiske personer, så er det jo også ofte sådan, at det kan være virksomheder, og det kan også være virksomheder, som søger om fri proces. Og som jeg sagde indledningsvis, så er det ikke udelukket at give en virksomhed fri proces. Men hvis søgsmålet handler om noget, som angår virksomhedens normale drift, så vil man meget, meget sjældent gøre det. Der skal være nogle særlige grunde til at meddele fri proces, også i den situation. Og hvis vi bliver ved de juridiske personer, de har ikke deres egen bestemmelse. Jeg ved ikke, om man kan... Det er måske lidt underligt, men de ligger, det kan man faktisk ikke engang se der, de ligger i undtagelsesbestemmelsen. Og det er jo ikke fordi, at jeg skal sidde og føre jer igennem alle disse undtagelser, men hvis I kan huske denne her med de 3 trin, den nederste, som handlede om 329, undtagelsesbestemmelsen, det er en samling af undtagelser fra en hel masse forskellige ting. De økonomiske betingelser, retshjælpsforsikring, og så var der de særlige grunde, den principielle, offentlig interesse, særlig betydning for ansøgeren. Og så er der også de juridiske personer. De ligger også i den, men det kan man kan faktisk slet ikke se det i loven, men det følger af praksis. Hvis en juridisk person skal søge om fri proces, så skal de også opfylde de økonomiske betingelser. Og der kan vi jo ikke bruge de indtægtsgrænser, vi så før. Så der bliver vurderingen lavet på baggrund af et skøn over, hvis det er en virksomhed, eller det kan også være en forening, over regnskabet. Hvis det er en forening, så tager man også stilling til, hvor mange medlemmer, om foreningens medlemmer sammen med foreningen i fællesskab kan bære sagens omkostninger. Jeg har ikke rigtig styr på tiden. Hvad siger du? Det er næsten slut. Okay, godt. Jamen, jeg er også næsten slut. Ja. Jeg ved ikke, om jeg lige kan nå at sige lidt kort om retshjælp til klagesager ved internationale klageorganer. Det er jo ikke noget, vi har hørt nævnt her fra nogle af de andre lande. Det er en ordning, som ikke er nævnt i retsplejeloven. Den har sin egen lov. Og de sager, der kan komme på tale, det er jo typisk sager, som bliver ført ved den europæiske menneskerettighedsdomstol eller ved forskellige FN-organer. Og ordningen er sådan, at hvis det internationale klageorgan har anmodet den danske stat om retlige bemærkninger, så skal vi give retshjælp. Hvis der ikke er anmodet om retlige bemærkninger, så kan man give retshjælp, hvis sagen er principiel eller af offentlig interesse. Denne her ordning, den gælder kun fysiske personer. Og det retshjælpen består i, det er, at Civilstyrelsen fastsætter et passende salær til den advokat, der har bistået klageren under sagen, når sagen er slut. Ja. Var det det? Ellers så kører jeg bare videre med noget andet. Godt.
Vi tackar Astrid för hennes föredrag. Och nästa talare är Kasper Sölbäck som ska tala om hur regler om rättshjälp fungerar i Danmark. Han är advokat och arbetar nu hos Danmarks advokatförbund och han arbetar med rättssäkerheten inom skatterätten och processrätten. Varsågod.
Well, in solidarity with the Finns, I will do this in English. First, I would like to take the opportunity to thank our hosts for hosting this conference. I hope that we can get inspired from each other and find inspiration in each other's arrangements on legal aid. Because, as it was said at the beginning of this conference, our countries are very similar and have a lot in common. So. Right, the outline of my presentation is I will do a first short introduction of myself, and then I will describe another aspect of the legal aid system in Denmark than the one that Mrs. Mavrogenis described. And then I will do a bit of legal history concerning the rules that are in place now, and what the lawyers' feedbacks are on these. And also, I will finish with the way forward to describe the work that is currently being done to improve these legal aid arrangements. But as I said, I will introduce myself first. My name is Kasper Sølbæk, and I'm a lawyer from Denmark. I graduated from the University of Copenhagen in 2009, and I began working as the legal advisor to the Danish government, which in Denmark is a private law firm called Kammeradvokaten. And I worked there for almost 5 years, first as an assistant lawyer and then as a lawyer. In January this year, I started working at the Danish Bar and Law Society, and it's in that capacity that I'm here today. So my presentation will concentrate on the roles that lawyers play in legal aid and how they experience the rules. As the Minister of the Interior opened the conference with, a society based on the rule of law such as the Nordic countries are, it's paramount that every citizen, no matter what their financial capabilities are, that they have an access to justice. Because the rules that govern the modern society are so complex and so diverse that for an ordinary citizen, it's difficult to determine whether or not that person has a justified claim or whether a claim against them is justified. And that goes even more for citizens with few resources. One might call them weak citizens. So they need help. They need qualified legal help to navigate this jungle of rules. Therefore, it's also important that the state provides this help. And apart from the system that Mrs. Mavrogenis described, there is an arrangement in Denmark called retshjælp ved advokat, which roughly translated means public free legal aid by means of a lawyer. It's a bit shorter in Danish. And there's 3 levels of this form of legal aid. The first level is something called advokatvagter. I will describe more into detail what that involves later. But it's the state provides basic funding for these. And then there's 2 additional levels. The second level is limited legal advice, where a lawyer can do some limited casework. He can write, or he or she can write letters and do very basic either statements of defense or subpoenas. On the third level, there's counseling in connection with settlement negotiations. But if we start with advokatvagten, which is the first level, it can best be described as a legal emergency room. Basically, the idea of this institution is that a lawyer or a group of lawyers are present at, for instance, the local library, one night a month or more frequent, so that anyone with a legal question can drop by and get advice. And this is done in more than 80 places all over the country of Denmark, even in the more remote parts of the country. And each year they get more than 20,000 inquiries. This advokatvagt, or advokatvagterne, is open for everyone, regardless of their income. And the advice that the lawyers provide in this forum are short, oral advice. They don't write letters and they don't handle the person's case. It is merely short oral advice, as I mentioned. And the basic idea of this platform is to help the person who comes there to understand whether or not the problem or the conflict that they're involved in, if it's worth pursuing. So it works as a filter for that person to determine whether or not they should spend more time, energy, and money on this case. According to the ethical standards of lawyers in Denmark, the lawyers can't offer their services themselves. If they find out, or if they realize that a case is worth pursuing, they can't say, I will take this case. They will say, this case is worth pursuing. I suggest that you find a lawyer who can take this case. So the work that the lawyers do in these forums is in addition to their ordinary jobs. And it's purely volunteer work. And as I said, that there's more than 80 of these advokatvagter in Denmark. And on the homepage of Civilstyrelsen, which is the ones who are paying the funding, it's stated that 64 of these advokatvagter is getting funding from the state. And some of this funding can, in theory, be used to pay a symbolic fee to the ones who are there. But the remaining advokatvagter, which is more than 16, they don't receive any government funding, so they are purely there voluntarily. So despite the reputation of lawyers, they're not all greedy sharks. The Danish Bar and Law Society also supports these advokatvagter in different ways. First, we are operating and updating a homepage which shows the addresses and the opening hours. And it also contains information for the lawyers who want to start such an advokatvagter. But the most important thing is that it also contains information for the citizens on how they should prepare for a meeting there. And it's in both Danish, English, Turkish, Arabic, and Somali. And secondly, the Danish Bar and Law Society has helped secure funding from a private fund to provide each of these advokatvagter with electronic tablets in order to help the work there. As you remember, there are 3 levels. The second and the third level have much in common when it comes to the conditions in which they can be given. In order to get the legal aid on the second and third level, the person has to fulfill the same economic conditions that Mrs. Mavrogenis described before, the income level. And there's also restrictions on which types of cases that a person can receive legal aid to in the second and third level. You cannot get it for criminal cases which are being handled in administrative entities in the government, and it can't be given to cases concerning business law if the one seeking it is the professional party. So a consumer can get it, but not the business. And there's also a maximum of how much a lawyer can get as a fee under these levels. The second level is maximized currently at 1,010 Danish kroner, which is roughly 24,000 Icelandic kroner. And the third level is maximized at 2,320 Danish kroner, which is roughly 55,000 Icelandic kroner. On the second level, the state covers 75% of it, and the citizen has to pay 25%. On the third level, it's split 50-50. And just to clarify, this was not an hourly rate. This is the maximum fee that you can get. And these arrangements are secondary to private insurance. If it's covered by the private insurance, you cannot get this you can't get the money from the state. The fee and the process of how to get it has been the subject of complaints by the lawyers, and this is where the short legal history comes in. Because these rules with the 3 levels were introduced in January 2007. And in the following years, a high number of lawyers contacted the Danish Bar and Law Society and complained that they felt that the new rules needed improvement, to say the least. And the problems that they experienced primarily fell into 2 categories. First of all, there was the administrative side. In order to get the legal aid in levels 2 and 3, the lawyer has to fill out a rather detailed form in order to get these funds. And this way of administering the funds was experienced by the lawyers as being bureaucratic and was seen as an obstacle to get it. And secondly, there was the economic perspective. As I mentioned before, the fees are 1,010 Danish kroner and to almost 2,300 on the third level. And the complaints from the lawyers were that these amounts hardly covered the costs of opening the cases and making the application for the legal aid. A valid point is that you can say that lawyers are just greedy and they should just settle for what they can get. But if you compare it to the amounts that other service professions charge in Denmark, the fees offered are not extravagant. The last time I had my bicycle repaired, the repairman charged me 1,200 Danish kroner a month. An hour, sorry. It's not my role here to fight for increased lawyer fees, but it's the fact that having a law firm is a business. And if the fees from the legal aid can't even cover the costs of making the application and opening the costs, then from a business point of view, there is absolutely no incentive to do these legal aid cases. This has led to a serious decrease in lawyers who are interested in working with these cases. The application has been regarded so burdensome by some lawyers that they don't want to bother with it and just do the work pro bono. But the majority of lawyers have just turned away the clients and have left them without legal aid because it's not, there is no business in this. In the opinion of the Danish Bar and Law Society, it's not advisable to base legal aid and access to justice on the kindness and willingness of lawyers to work for free. It isn't sustainable, and it doesn't secure a fair justice system for all the citizens. And it's especially the less resourceful citizens whose access to justice suffer from this. And Denmark, which pride ourselves of our legal system and our welfare system, can and should do better than this. So in 2009, the Danish Bar and Law Society made a collection of the elements of the Danish laws that we felt were problematic, and we gave some recommendations on how to improve them. Among other things, we recommended that the Ministry of Justice formed a broad commission consisting of a wide range of organizations to revise the current rules on legal aid. But unfortunately, the Ministry of Justice didn't follow that recommendation. However, some serious facts came into play. There was a lot of critical articles about the legal system which put some pressure on the Ministry of Justice. But most of all, and what I think is the most revealing on this, is that the Ministry of Justice found out that the spending in 2004 to 2006, which was before the new rules came, was about 21 to 23 million Danish kroner a year. Since 2007, it's been between 6 and 10 million. So there has been a decrease to half or even a quarter of what it was before after these new rules has been implemented. And confronted with these facts, the ministry asks an advisory council in March 2010 to assess the current rules and to see if they were satisfactory and to make recommendations if they weren't, but within the current economic frame. So the work description for this council was somewhat narrow. The conclusion of this council was that even though there was a decrease in the lawyers' interests, the council still thought that it was possible for citizens to get qualified free legal aid. However, there was a minority of this council that highlighted that there was a need for a thorough structured analysis of the public legal aid. So at least we got through to some. In June 2012, we, along with the organization called Danske Advokater, Danish Lawyers, which is a lobby organization with the focus on the commercial interests of lawyers, commissioned an economic consultancy company called Copenhagen Economics to make an analysis of the development of the rules of legal aid since 2007 and which consequences it had on the society. Among the findings of the report was that less than 1 in 5, that's less than 20% of the lawyers in Denmark, were interested in doing these cases covered by legal aid. And the ones who were willing were primarily lawyers working in small firms, village lawyers, as one might say. And in a time where the law firms are merging into fewer and bigger firms, and the village lawyer is starting to be an endangered species, this is very problematic. But the overall conclusion was that legal aid in Denmark was suffering, and that this suffering would have social consequences. And as a result of these reports and the critique made by the two organizations, we held a meeting with the Danish Ministry of Justice. And as a result of this meeting, we were encouraged to form a working group, which was in place shortly after. And the aim of the working group was to pinpoint the problems with the current rules and to make suggestions on how to improve it. However, the ministry was very specific on one point: the economy. The suggested improvements were not to lead to increased costs. So, again, a somewhat narrow work description. At present, the working group is consisting of 6 lawyers and a law professor from the University of Aarhus and a person from each of the 2 organizations. And it's being considered to enlarge the number of participants and the number of organizations in order to get a broader perspective. And, as I said, we're working on preparing concrete suggestions on how to improve the legal aid in Denmark. So my participating here has been I've got a lot of inspiration from this conference. And so far the working group has met twice, and the next meeting is scheduled for the end of this month. And we hope to conclude the work by March next year. The goal is to improve the legal aid rules and hopefully make sure that every citizen in Denmark, regardless of their financial capabilities, have a real access to justice and not just a formal one. It is the basis of a democracy, and it has to be available to all citizens, also the less resourceful, in order for a democracy to work. And that is my presentation.
Tack så mycket, Kasper. Nu är det dags för frågor igen. Några som vill föreställa frågor? Ja, varsågod.
I would like to pose the question in English.
Yeah.
I'm curious to know from each of the Nordic countries if when an individual is provided legal aid for a court case, does the legal aid cover the costs for different court levels, from the district court to the higher courts? So, or do people have to apply in between court levels? So,
We start with Finland.
yes. So it covers, yeah.
Okay, but if the case continues very long, it might be so that when case goes to Court of Appeal, court might ask that is this person still entitled to this legal aid? I mean, if his income has rise, then the case is different, but if it stays the same, you don't have to apply a new legal aid.
Okay, so they don't evaluate the merits of the case, only the economical aspect.
Okay, Sweden.
Sweden is like that.
Okay, Norway.
No, you have to apply for each court level.
Yeah.
And lastly, Denmark.
Fri proces gælder, hvis man har vundet sagen helt eller delvist, og sagen er appelleret af modparten, så har man automatisk fri proces. Heller ikke nogen nye økonomiske betingelser, den kører bare videre. Men hvis man har tabt sagen, så skal man søge ind.
Okay. flera frågor? Inga flera frågor? Questions? Då fortsätter vi bara med nästa. Och ja, just det. Då bjuder jag Åsa Ólafsdóttir välkommen. Hon ska tala om regler om rättshjälp i Island. Vi är i Island nu. Åsa är docent på juridiska linjen i Islands universitet och ordförande för rättshjälpskommittén i Island. Varsågod, Åsa.
Dear guests, it has been a real pleasure to sit here today and listen to your presentations. It has been very enlightening for me, and it has been a pleasure to hear about the different systems. It's my turn now to describe the Icelandic rules on legal aid, and I have decided to use this opportunity to give a broad outline of the system and of the people working within the system. I will also try to look at the what merits the case has to apply, what rules apply when measuring the merits of the case, and whether to grant legal aid. So, as you have probably learned by now, I will be addressing you in English, and so I'll start by describing the legal foundation for legal aid in Iceland, and the rules on legal aid are in four articles in the civil procedure law. It's in Article 125 to 128. So there are 4 articles concerning legal aid, and on the basis of these articles, the Minister has issued a regulation from number 45 of 2008. Now this regulation has been amended 2 times, in 2010 and 2012. The amendment in 2012 was to higher the estimation for income of the people asking or requiring legal aid. So the foundation is found there in the Civil Procedure Act. This act is from 1991. There is other specific legislation on legal aid that applies in specific cases, most notably the Act on Child Protective Services and the Act on Adoption. And I will not be addressing those acts today. Also, there is a possibility to apply for legal aid when a police investigation has been dropped and people are requiring or seeking damages that follow this police investigation, and I will not be addressing them here today. Only I point to these acts because an applicant for legal aid in these more specific cases does have to follow the exact same application procedure when applying for legal aid as in the civil cases. So I am a chairman of this legal aid committee that takes these applications into considerations, and we receive both applications for civil cases as well as cases where damages are sought because of police investigation that has been dropped. Just some information or data on how many cases we receive each year. So in 2011 we received 532 cases, and in 2013 we received 572 cases. And these are applications that we have received and processed at this Legal Aid Commission. So who can apply for legal aid? And the answer is that all individuals involved in a judicial proceedings in Iceland can apply for legal aid. There is no distinction done here between Icelanders and foreign nationals. The only distinction or only condition we have is that this is a person who is involved in judicial proceedings in Icelandic courts. We have foreigners who have received legal aid, and also children and minors have also been awarded or granted legal aid. This has not been extended to legal entities. So companies, residents associations, non-profit associations or organizations are not eligible for legal aid according to the Icelandic system. So, just to stress here, I will address this later, that the legal aid does cover the cost of civil court proceedings, but the costs are awarded and decided by the judge who resides over each case. It is not the minister or the legal aid committee that decide or puts a limit on the cost. It is the judge in each case that decides what the costs are. So also another point here is that we do not have legal aid for administrative cases. Just a quick lecture in Icelandic law. We do not have any administrative courts. Although we have administration complaints committees, various complaints committees, but the legal aid does not reach out for that. So the legal aid does not cover administrative disputes. And this has been criticized by lawyers in Iceland, and a proposal for a parliamentary resolution was put forward in 2003 so as to include costs of administrative proceedings, but that did not lead to a change made in the law. So, in fact, the legal aid only covers the court proceedings. Now, the application procedure is that a legal aid is granted by the minister, as the minister described herself this morning. And the decision is an administrative decision, and it has to be taken on the ground, on the basis of the opinion of this legal aid committee. So what happens is that the application is directed at the ministry, and it is required to be in a written form. And I'm sorry to say that use of electronic applications has not yet been put in force, although work has started in that respect. So in fact we deal with a lot of paper. So this application can be for a district court case, or a case before the Supreme Court. And directly to answer this question that was asked here just now, is that if a case is won, if an applicant has received legal aid in the district court and he wins the case, he is granted free process or legal aid if the case is taken to the Supreme Court. Usually it will not be the applicant who is taking the case to the Supreme Court, it is the opposite party. But if a case is lost, then the applicant has to reapply for a new legal aid for this Supreme Case Court. So, an application is granted or handed in to the ministry, and when making the decision on whether to grant legal aid, the minister is bound by the opinion of this legal aid committee. This committee either recommends that a person be granted legal aid or does not recommend legal aid. But there is a twist, because if the committee is in favor of granting legal aid, the minister cannot override the committee's opinion. if the committee is not in favor of granting legal aid, the minister cannot override the committee's opinion, but if the committee is in favor, the minister can decide not to grant legal aid, despite of the committee's opinion. So this committee is an individual committee. It has 3 members. It's independent from the ministry, and there are 3 members in this legal aid committee. 1 is appointed by the minister, 1 is appointed by the Judges Association, and 1 is appointed by the Bar Association. So how is the application procedure then after the application has been handed in? Then the legal aid committee looks into the merits of each case, and it looks at various factors regarding the case. It looks at whether the most important condition is whether this case is likely to succeed at court. But there are other things that the committee looks at, and in the regulation that I told you about from 2008, the legal aid committee is required to look at whether this is a dispute related to the business of the applicant, or whether it's between closely related individuals, or whether the applicant has shown grave negligence in trying to get proof or evidence in his case. We can also, or the legal aid committee can also see whether the circumstances and arguments are clear enough so it's ready to be processed at court, or whether the applicant has tried to solve the matter outside the court. So these are things that the legal aid can look at whether when deciding on the merits of the case and whether this legal aid should be given. Also, it can look at the finances of the applicant, or to whether the outcome of the case would have a great general significance or other matter greatly to the applicant. So these are 2 independent conditions. The latter one was reintroduced in the Icelandic legislation in 2012. It was taken out of the legislation in 1995. It was in the legislation from 1991. And this is, if a case meets these requirements, then there is no need to look at the finances of the applicant. So this is a special condition that if it's met, then there is no need to look at the finances of the applicant, but the case has to stand, or it has to be of merits. The merits of the case must meet the first requirement. In 2013, that was the first year that we had this new condition in the Civil Act, and that year we had around 30 cases that met this requirement. So that is in use. This requirement is in use and used by the Legal Aid Committee. But the finances of the individual, they are, as described on this slide, they are rather low compared to the information that we have seen here today. The applicant's annual income should not exceed 2 million Icelandic krona, and that's 12,947 euros as calculated yesterday. Also, if the applicant is married, the annual income of the family, or the family married or living with another person, it should not exceed 3 million Icelandic krona. A deduction is made for each child living with the applicant, and here we have no limits to how many children live with the applicant, and it's 250,000 krona for each child. So these are very low numbers. and lawyers in Iceland have criticized these numbers highly. They think they have put forward the argument that these numbers should be raised. And they have been raised. They were raised, as I said, in 2010, but the lawyers claim that these numbers are so low that no one really can get through these or get legal aid with such low numbers. But as I said, if the applicant has based his application on the second part of the Article 126, where the outcome of the case would have a general significance or matter greatly to the employment, social status, or other personal status of the applicant, legal aid can be granted regardless of the financial situation of the applicant. So the next 3 slides I will show you contain a bit of graphic information on legal aid. And I'm really fond of these pictures because we have tried to look at these cases and decide or see information on legal aid that divided up by years and by the genders. So the first slide shows the types of cases that we have received at the Legal Aid Committee. And there are 3 prominent cases there. I will translate them for you from Icelandic. But the first or the largest number of cases are custody cases, where parents are disputing over custody of their children. This is the third from the left. There is a drop. There was a continuous rise of these cases. They were growing in number every year. But in 2013, we got a new act in respect to children, where it's now, and that act in fact explains the drop in those cases, because it's now required that parents go to a magistrate's office and try to resolve their matter before going into court. So that is explaining why there's a drop there in the green column on the third from the left. Now the second or the fifth from the right is, these are personal injury cases, and they are always, lots of them always, and they come to us at a steady pace. And the rather vague other cases, the far right column, the rise there in 2013 is largely due to cases or applications from asylum seekers, that have requested their application to be processed in Iceland and not instead of being sent back on the basis of the Dublin Agreement. So I have a rise there. That explains the rise in these other types of cases. So here we have a breakup between the genders, as I promised. I had to make a correction in the slide, so it's correct here. It is wrong in the slides that were printed. So the red column, this is an overview of legal aid that was granted in the years 2011-2013, and we can see that the red column it shows cases that were awarded on rules on civil cases that were awarded in these years, and there is really there are in fact not such a difference between men and women there. And the blue column are other cases, like cases for child protective services and claims from the police, investigations, etc., that we process but are not part of the civil procedure. But it's also interesting to see where application has not been granted. And that is shown here. Refusals, it's called, in 2011 to 2013. There are 3 columns there, and the green column is dismissal from the legal aid. We have the legal aid can dismiss a case if there is not sufficient documentation, or as in 2013 when there was this new law on child, this new act concerning the child, where it was a requirement to go first to the magistrate's office, and lots of applicants had not done that before applying for legal aid. So these cases were dismissed. Also, the red one, that shows the distribution between genders when dismissing an application on grounds of financial situation. And you can see that more men than women were refused legal aid on grounds of high income, and that mirrors, in fact, the distribution of wages in the Icelandic work market. But the most delicate and by far the most controversial part of this column are the cases where the merits of the case are deemed not to be sufficient. So they are the blue part of the column. But note that even if there has been a rise in applications in the years 2011 to 2013, so there are more cases that were received in 2013 than were received in 2011, but there are fewer refusals on merits. So the refusals are going down, but the applications are going up. And also it is important to bear in mind that, as I said earlier, if a person has lost his case before a district court, he has to reapply for legal aid if he wants to go and take his case further to the Supreme Court. So the Legal Aid Commission or committee is required to look into the merits of the case yet again to see if there is ground for a referral of the case to the Supreme Court. So some of the persons that got a rejection there had their possibility in court at the lower level. And this is the final slide. It's just that, because it has been such an interesting afternoon for me to listen to all the other Nordic countries and listen to your rules on what the legal aid, especially what legal aid covers, because we do not have similar, or our system mostly, it's reflected, I think, best in a Danish system, although we do not have exactly the same system. But the legal fee is, if a legal aid is granted, then legal fees are paid. But this is, as I said, legal fees are decided by the court. Also, costs of obtaining evidence are also granted. There is no limit here. So this can be a high amount, especially in custody cases where we have to have reports from expert witnesses, and they are very expensive. But they are paid if legal aid has been granted. Also, it gives you an exemption from court's fees, and they can be extensive. And it also, and that is not on the slide, but it also covers all the costs of collecting the claim at the magistrate's office if the case is won. But no participation is required from the applicant in order to obtain legal aid. There is no, as the other systems, as I've understood you today, that the applicants are required to pay a set sum or a percentage of the legal fees, but that does not apply here. However, the Legal Aid Committee can recommend that the legal aid should be restricted, and usually does this in cases where it is the desirable that desirable that the claimant and the counterparty agree or come to an agreement out of court. And this has usually been used in custody cases. So first they give the Legal Aid Committee recommends that the legal aid be restricted to a certain amount, but if and when the costs have exceeded this first restriction, the applicant can reapply if he shows that the costs have exceeded the estimated costs. And usually they are granted an unlimited legal aid if that is the case. Now, this is the final point, that this does not cover if a person has received legal aid and he goes to court and loses his case, then he is liable, or he has to pay the cost of the opposite party. This is not covered by the legal aid system. So that is a chance that is taken by person who apply and go to court with the legal aid. And that has happened in some cases. Also, another threatening factor that I'd like to mention here is that we have also seen types of individuals getting or being granted legal aid, and they go to the court, and the opponent asks for a guarantee of repayment of these costs, the opposite party. So that might threaten or undermine the whole base and system of legal aid, because the judges have accepted that the applicant put up an insurance or a guarantee for the cost of the other party. And usually if people apply for legal aid, they do not have the funds necessary to do that. So that might restrict their access to justice. So I have now described in broad strokes the rules concerning legal aid in Iceland, and I hope I have shed some light on the issues. And before I'd like to thank you for your kind attention, I will direct you to ask me questions if some things are unclear later on. Thank you.
Vi tackar Ása för hennes föredrag. Nästa talare är Þyri Steingrímsdóttir. Hon ska tala om hur regler om rättshjälp fungerar i Island. Þyri Steingrímsdóttir är advokat och har arbetat inom familjerättsliga frågor i 10 år. Varsågod, Þyri.
Tack, kära nordiska vänner. I'm going to speak in English, not in Danish or Scandinavian language. And also, like Ása and other participants, want to thank you all for a very interesting day, and it's been very interesting to listen to all of your speeches and compare with our system here in Iceland. Some things are similar, some things are not, so it's been very interesting. I just want to pick up some points from where Ása left off and try to go over how this is working for the advocates, for the lawyers here, and sort of in real life, if you will. This text on this slide is sort of taken directly out of the regulation regarding the legal aid, and the underlined parts I'm going to go over a bit more. Firstly, the Legal Aid Committee, as Ása has said, assesses the merits of the case. This has been widely criticized here in Iceland, since the question always arises, is it not for the judge and the courts to decide on the merits of the case, but not a committee appointed by the government or other entities? And also the parameters of this judgment of the merits of the case, as also described here, this has not been, in my experience, some merits are more equal than others. So there is no telling, or at least in my experience, I have not been able to understand what merits weigh more than others, and it has not been any sort of a line through there that you can depend on, that this sort of case will go through the Legal Aid Committee on the merits, but the next similar case doesn't go through on the legal merits. So this has been a major problem in my view regarding the application of legal aid. The second part, of course, the income of the applicant. As was described here, the income cap is much too low here in Iceland. It is ridiculously low. It is only 2 million per year, which is roughly 13,000 euros. As has been described, if I have understood it correctly, in Sweden it is 28,000 euros. In Norway it is 30,000 euros. In Denmark 40,000 euros. Here 13,000. So the difference is huge. And this 13,000 euro cap, the limit, it is lower than the unemployment benefits per year granted by the government if you are unemployed. So as has been said here, really no one can fulfill this requirement. So, and this, of course, the restriction of access to courts is severe and serious. So, because the average wage, according to the public numbers here, the average pay for an individual in the service industry is around 4.8 million per year, which is 30,000 euros, which is the same as the Norwegians were describing here. 30,000 euros, but again, the cap is 13,000. So, and also, this average man with an average pay, this average pay is also considered low in society. So he has only the means to provide for himself and his family and pay from his mortgage. He has no savings, so he cannot retain a lawyer. He hasn't got the money to do it, but he doesn't either fulfill the requirements for legal aid. So really no one with the average income of maybe 4 to 5 million per year can file a lawsuit. He cannot afford it, and he cannot get legal aid. Other factors than pure income, like Ása described, this is maybe 30 cases per year. This is not. No, I'm sorry. No, I'm getting because other factors. Other factors than pure income. We are talking about economic factors, like if you are in much debt, or have a large family, or something like that. This is also common for a regular individual here in Iceland, especially after the collapse of the banks. All of our houses are overmortgaged, and you have little or no savings. But this has usually not come into any sort of consideration by the Legal Aid Committee. They are much too fixed on the income cap. Because as I was describing, the sort of a normal individual has this income of maybe 4 to 5 million per year. He has an overmortgaged house and no savings, but he cannot get legal aid. Then there is this requirement of granting legal aid regardless of the financial situation, which around 30 cases last year, as also was described. This, for instance, does not happen in family law. There are no such legal aid has been granted in family law regardless of the financial situation. There are some cases that have this mandatory legal aid, child services cases, paternity cases. This usually does not go before the committee. It is decided upon in the ministry itself. It is usually dealt with quite fast and is usually not restricted. You have to apply for it in child services cases, though, to the ministry, but in paternity cases you don't have to apply. The judge makes the decision regardless. Then there is also the point of that the legal aid doesn't cover administrative proceedings, which has also been widely criticized, because these that can of course be just as complex and expensive as court cases in some instances. According to the rules about the Legal Aid Committee, it should take about 1 to 2 months to get the process to go through the Legal Aid Committee. You should get an answer within 1 or 2 months. This is usually not the case. It takes much more than 1 or 2 months usually. Then it's very hard to get, you don't have any access to the committee itself or the committee members. If you are calling and asking what's going on with this application that I have sent, you get the secretaries in the Ministry of the Interiors, and the answer is usually, well, the committee hasn't convened. It will convene in 2 weeks, and maybe, I don't know if your case is going to be heard then, and so on. So in other words, computer says no. So you don't know anything. When you send the application, you don't know anything. Well, how long it's going to take, what's going on, until you maybe 2 or 3 months later you get the reply, yes or no. And of course, this represents a major problem in appeals. As has been described here, you have to apply again if you want to appeal a case. And the appeals notice in, for instance, custody case is 1 month. So it takes the Legal Aid Committee a longer time to process the application than the appeals process is. So you have to decide, am I going to go forward with the case if I don't even know if I'm getting legal aid for the case. And again, the Legal Aid Committee then starts to evaluate the merits of the case in the appeal, and of course then making a judgment over whether you should appeal the case or not, which is not the place of a government-appointed committee. It is the place of the lawyers, and then of course before the judges in the Supreme Court. So these are mostly the points that I would like to make about the procedure with the Legal Aid Committee. This is widely criticized and much talked about in the Society of Lawyers here in Iceland. And the next point is, what does legal aid cover? And again, these are excerpts from the regulation, and the underlined points I'm going to talk about a little further. As has been talked about, the legal aid covers the legal fees payable to the state treasury. This is the court fees. This is it varies from case to case how high the court fees are. In custody cases, there are no court fees, so it doesn't really matter in the cases in the family law. Then there is, of course, the legal costs, including the lawyer's remuneration or the legal fees, which is, again, the major point that the lawyers have criticized here in Iceland. As Ása described, it is not the Legal Aid Committee that decides on the amount in legal fees or decides on the hourly rates. It is the judges in each individual case that decide. Typically, the lawyers' hours are re-evaluated and downsized, and typically the hourly rate is set at around, now around 14,000 Icelandic kronas, which is around 90 euros, but was until recently 10,000 Icelandic kronas, which is about 65 euros. But a usual hourly rate of an Icelandic law firm in cases regarding individuals is around 22,000 Icelandic kronas, which is 140 euros. And it has been interesting for me to hear from the other countries also here what this hourly rate has been. If I have understood it correctly, in Finland the legal aid is 110 euros, in Norway 118 euros, but the usual hourly rate for individuals is twice that. So it is similar to here, and this is of course a major problem, because you as a lawyer, you can only work with half of your usual hourly rate, and with us here in Iceland, we are subject to downsizing of the hours by the judges. And usually the judges make their decision without any explanation or any grounds that to us lawyers. It is just one line in the judgment, the legal fee should be this much. We don't get any explanations. Why are you not following our hourly rate? Why are you not following this report that I have given about all the hours that I have put into this case? So the question arises, why should a lawyer want to work within this system, where you have absolutely no say in what you are getting paid for the case? And does this ensure people the best possible legal assistance? I don't think so. This has, here in Iceland, had the effect that experienced and good lawyers don't want to take legal aid cases. The legal aid cases go to the new lawyers, the inexperienced lawyers, who maybe don't have other cases. So they reach into this pool that is the legal aid cases. And the result is these people who are weak, as we were talking about here before, they don't get good legal representation, unfortunately. And then there is the question of charging the client for the difference, like has been described here with as I have understand it, the applicant can have participation in the legal fees. This is not the case here. Lawyers are not allowed to charge their client for the difference unless they have, in the beginning, made a written statement where they obtain the right to charge their client for the difference. So if you have to put it in writing in the beginning, when you get the ombud for the case, that this is probably a legal aid case, I will apply for your legal aid for you, but I obtain the right to charge you for the difference if the judge decides on a fee that is not the same amount as I evaluate that should be charged for the case. But of course, as we have talked about here, like my Swedish colleague was talking about, that you don't have the opportunity to charge these clients. They don't have the means to pay. So you are, in effect, taking these cases with the chance that the judge will do good or be in your favor and grant you an amount which can go over all the hours that you put in. Then there is the third point, that the legal aid can be restricted to a certain amount of money in cases that should be settled out of court. And it is sometimes restricted to legal fees and the evaluation of one court-appointed specialist. This is only in custody cases. This seems to be the only cases that custody cases seem to be the only cases that the Legal Aid Committee deems as cases that should be settled out of court. But the problem is custody cases that have come to the point that you need to go to the court, they have already tried to settle them out of court. It is now mandatory by the Barnaloven, the Children's Act. You have to first go through a mediation process with the civil authority before you are able to apply or go to subpoena and go to the court. So you have already tried to settle out of court. But then again comes the opinion of the committee. No, you should still settle it out of court, and we will grant you it's 400,000 Icelandic kronas, which is around 2,500 euros. And you can't try a custody case with 2,500 euros. It's impossible. And then but then you are supposed to, as also was describing here before, just reapply. But why? Why should I want to reapply? Why don't I get the legal aid in the beginning? What is this process for? This has been highly criticized, because for 400,000 or 2,500 euros, it may be maybe 20 hours of work, 25. But as I understand from Finland and Sweden here, it is capped at 80 hours and 100 hours. But this is 25 to 30 hours, 25 hours at most, really. So this is, and of course also in the custody cases, which in the opinion of the Legal Aid Committee should be settled out of courts, are usually settled in the court. There are extensive settlement negotiations in custody cases within the court, which take up a lot of time and are often very complicated and represent a lot of work for the lawyer. And it is much more than 25 hours, believe me. But at the same time, the evaluation of the court-appointed specialist, that is never downsized. It is always paid for in the legal aid process in full. So sometimes the specialist, which is usually a psychologist, he gets paid more than the lawyer. And there is no evaluation by the judge on the hourly rates or the number of hours or anything like that from the specialist. He gets his fee as he has demanded it. So this is my main critical point that I would like to make here. It is these decisions by the judge, and is these restriction with a certain amount, because the amount is not realistic. I would like to add here some points which I thought were interesting, which I heard from the other Deltari here, that there has been some reference to legal insurances. Like as I understood it in Sweden and in Finland, you have to first go to your then private legal insurance before you can apply for the legal aid. This is not the case here. Legal insurance in Iceland is relatively new. It's and not as common and not as extensive as it is, at least as I think I understand your description here today. And for instance, in all the legal insurance that I have seen, at least, the rules from the insurance companies specifically exclude custody cases. They specifically exclude cases regarding from the dissolve of assets in marriage or something like that. So this legal assurance isn't very good here. And also because the Danish, you're talking about the advokatvakten, we have that here on behalf of the Icelandic Bar Association. There is always this advokatvakten once a week, but it's purely voluntary. It's not paid for by the state. It is paid for. The Icelandic Bar Association provides an office, and the lawyer is there once a week for 2 or 3 hours, and you can drop in and ask the lawyer questions or call or something like that. But that has nothing to do with really the legal aid or the legal aid system. It is purely a voluntary scheme provided by the Icelandic Bar Association. Yes, the cost of the system, the cost that has been allocated into the system, I think as my finding is, as I think we can all agree in all the Nordic countries, there simply isn't enough money in the system. Maybe the system is okay. Of course, there are some points that can be criticized more than others and different by country, but I think we can all agree there simply isn't enough money in the system. These are numbers that I took from the state account from 2013 and 2012, and you can see what is called opinber réttaraðstoð, the legal aid, was 375 million Icelandic kronas last year, which is around 2.4 million euros. Was 310 million the year before, but was, which is in the 160, that is the money that was allocated in the budget. So what was provided from the legal aid is twice as more than the government had allocated in the budget. And this has been roughly the same amount, this 375 million. I took a look at the government account from 2006, and that year it was 336 million. So it's 375 million in 2013. So there isn't much difference there, but the difference is, of course, that in between we have had inflation for and the bank collapse, and the number of cases has widely increased, but the same amount of money is allocated. And so, in closing, as I was saying, the system maybe isn't too bad. Of course, there are some criticism, of course, as I have gone over, but the system needs money. And the system needs to, of course, take into account the principle of the rule of law. You have the right to access to the court to settle disputes. But, as I have gone over, you don't have this right. You can't exercise this right as a normal individual here with a normal income and a normal household. You can't get legal aid because you have a too high income, but you have too low an income to be able to afford legal fees by yourself. So you don't have the access to the courts, and then the rule of law is in jeopardy. The application system, the legal aid committee, needs to be faster, as I have described, more transparent, as I think I've tried to describe with the merits of the case, and the need to understand the complexities of the case, and also in cases that should be settled out of court. The decision-making system, the judges need to make reasonable and well-grounded decisions regarding lawyers' fees. If we are going to have the system that the judge decides what the fee of the lawyer is, they can at least make it a grounded and reasonable decision. In that way, you can perhaps provide good legal assistance through the legal aid. Thank you.